Welcome to Case by Case. This is a podcast brought to you by Calum Chain and Luke Savkiewicz from ZFZ. How are you, Calum?
I'm great, Luke. How are you doing?
I'm good. I'm coming up for air, to be honest. I've been handling a casualty case all last week up in the Arctic. So, been a tense one, but coming out the other end of it, thankfully.
That's a fun one. An Arctic casualty.
Yeah, always busy. And today we've got a shorter one. We've got a London Arbitration summary to get through.
We've got one of our quote unquote 10-minute episodes, I think.
Is it possible for us to do 10 minutes? Like, it's just starting from the case. History suggests not. Okay, let's try, hey? Let's try. Okay, so no more mucking around. Let's get straight into it. It's Lloyd's Maritime Law Newsletter, London Arbitration 723. It came out very recently, June 2023. We're in the world of shipping. We're looking at redelivery of a vessel. There were problems experienced by this vessel. We have a time trip charter where the vessel was supposed to deliver in India or Pakistan in charterer's option. There were issues and the vessel was damaged at Pakistan, I think it was, in Gadani. And then the vessel went over to near Fujairah, I think it was, and had repairs done there. And the charterers then purported to redeliver. And owners said, well, you're not supposed to redeliver here. You're supposed to redeliver the vessel back in India or Pakistan under the charter. And then they brought a bunch of claims related to that, some for additional crew bonus for having to sail through a war risk area and loss of a fixture and some other related claims as well in there. So it's all about what happens at the end of a time charter party and looking at when charterers do not deliver the vessel back where it should be redelivered and what happens thereafter.
And I like the emphasis on where, because here we're talking about a question of where is the ship redelivered, not when is the ship redelivered. And that's a different question, but ultimately with a similar answer, if London Arbitration 723 is to be believed. And actually my view is it is to be believed. I don't know what your thoughts were on this one, Luke, but I think that this is an example of the tribunal getting to the right conclusion.
I agree. I didn't have any commentary really to make on the outcome of this one. So perhaps we just kind of skip through each of the claims. We had the additional crew war bonus was dealt with first, at least in the summary.
And there were two clauses here whereby charterers could be liable for a payment to the crew. So what's happening here is the crew are being asked to sail through a high-risk area, and the owners are therefore paying their crew some bonus on account of the additional exposure to risk that they are facing. And owners would then want to recover this back from charterers because obviously it's charterers who have ordered the ship to go through that high-risk area. There are two clauses here. The first one was in the piracy clauses, and this is under the heading costs. It said, if the owners become liable under the terms of employment to pay the crew any bonus or additional wages in respect of sailing into an area which is dangerous, then that actual bonus or additional wages shall be reimbursed to the owners by the charterers. The second one was the BIMCO Standard War Risks Clause from 1993, which said, if the owners become liable under the terms of employment to pay the crew any bonus or additional wages in respect to sailing into an area which is dangerous, then such bonus or additional wages shall be reimbursed to the owners by the charterers. So very similar wording on both counts.
And so what you'd expect to see then is owners coming along and showing that they become liable under terms of employment to pay crews a bonus, right?
Exactly. That is, you think this is an absolute cut and dry slam dunk case, provided owners can simply show that under the terms of employment, they're required to pay the crew a bonus. And what happened here? They said, well, we weren't required to pay the crew a bonus, but it's customary to do so, and we elected to do so as a kind of ex gratia bonus payment to the crew, to which charterers said, well, you're not falling within the clause, we're not paying you.
And it was let's say, novel argument. I think the tribunal even said it's the first time they've come across this type of custom or necessity argument. So basically saying that, and I can kind of see where owners are coming from here. The crew is saying, well, we're not going to continue sailing. We've got a problem with this unless you pay us some more. And it might not technically be in our contract, but we're having to sail through a high risk area, and you should pay us. And I think the owners may have gotten somewhere if they were able to actually show evidence of custom or necessity, or that, even though it might not be exactly in black and white in the contract, maybe they get somewhere. I don't think it would succeed ultimately. I think it has to, you have to become liable under the terms of employment, and that's probably where it rises and falls. But what the tribunal said here is that there was no evidence to show that this custom or necessity argument even got off the ground.
And we've seen this before with custom of the trade. It's hard to argue to say there is basically a term that should be put into this contract because it's so customary, it's so normal, it's so everyday that when this type of clause is agreed, what they really mean, taking into account the customs of trade, is this other thing. That's a really difficult argument to succeed on. You need really good evidence, and here they didn't bring any. So unsurprisingly, clause wasn't satisfied. And owners didn't get the money back.
So moving on to the second head of loss, which is a subchartering and unsafe discharging operation. I must admit, I struggled a little bit here to understand what the loss was and what was it related to. So here, did you? I was kind of reading through thinking, what are they actually claiming here?
So what I think it was, and as ever, if you're involved in this case and hearing me completely butcher it, please get in touch. What I think it was that they were trying to reframe all the other losses as being losses for a breach of the requirement not to subcharter. So they were trying to say, it's correct to say that in the charter party, charterers were not entitled to subcharter the vessel. They weren't allowed to. It was a breach of the charter party, but they did it anyway. And obviously, owners knew that they had a slam dunk case for that breach. In terms of liability, they were fixed. But in terms of quantum, it was very difficult. It was very difficult for them to say all of this loss flows from your breach by subchartering, because actually the subchartering didn't really have any close connection to the losses that were suffered. And I think this section of the decision was effectively the owners saying all this loss is really caused by your subchartering, and the tribunal saying no, that's not the case at all. The cause of those losses was not the fact that the ship was subchartered, it was the fact that the ship was redelivered in the wrong place.
Yeah, I totally see that. And where it opens up and says sought to underpin their claim for losses. So it's the losses that they're claiming in the next section as well. It's almost an alternative basis. I suppose that's what threw me a little bit. It's an argument that you kind of see after the main argument. I wouldn't have thought this was the main way to put forward the claim for those losses, and it's the kind of catch-all. Can we get it through on a breach of this restriction on subchartering type argument? It failed, and I don't think much needs to be said on that, frankly. Did you have any comments to make on that? I thought it was pretty clear that there's no causative link.
I agree that there's no. You need that direct causative link between the breach and the loss, and here there wasn't that. The loss arose from a different breach, and to the extent that it's claimable, well, that's what we're about to discuss. And I find this quite interesting. You see this every now and again. What are your losses where a ship has been redelivered late, redelivered in the wrong place, redelivered in the wrong condition? And the key question that always arises is, can you claim a lost follow-on fixture? So you could have got this great fixture in the market had the ship been redelivered contractually. It wasn't, and you missed the opportunity to get that great fixture. Can you claim it back? And the answer here, and in so many cases, is no, you cannot, following the Achilles Supreme Court decision. Which I think, there was some debate on the way up in the Achilles, and there was actually a really interesting obiter comment in the Court of Appeal. I can't remember which Lord Justice it was, but they said effectively, if you overrun, this was in the context of redelivering late, and they said that the Achilles was a late redelivery claim, and they said if you are redelivering late, what you're effectively doing after the charter party is agreeing a new contract for the extended period. And it's feasible that part of the terms of that new contract for the extended period would be making good the losses suffered by owners for the fixture that they had to cancel for you to have it instead. It was a really kind of creative way of looking around it in these Arbiter comments, and the Lord Justice said basically this wouldn't work, but this is how you might try and shape that argument in a way that makes sense. If you have a late redelivery dispute or you're interested in this kind of thing, then the Court of Appeal, that Court of Appeal decision in the Achilles is a really interesting look at the way that you might try and shape that argument. Either way, Supreme Court said no. Your loss for you just don't get this loss for a follow-on fixture. Obviously, that case was looking at late redelivery, but it is applied here equally.
Well, that's what I was going to say. Is that that was a late redelivery argument, and here we're talking about a wrong location redelivery issue, and the tribunal agreed with the charterers here, and said that the same principles must apply in the context of a redelivery in the wrong place as well as at the wrong time. So, that was a helpful comment to the extent there was any doubt about that, and I'm not sure there was. And they referred to the passage in Cook's judgment in Maestro Bulk and Costco Bulk, the great creation case in 2015. I think this is a useful quote to read out. It is the very nature of the follow-on fixture when compared with a hypothetical follow-on fixture, which gives rise to the notions of unquantifiability, unpredictability, uncontrollability, and disproportionality at the date of the charter, even if the fixtures can be quantified ex post facto. And it's this notion that it's hard to quantify. You wouldn't know what it is. And I always wonder about these kinds of cases. I've had this thought. I've actually had this debate with a colleague at another firm before around foreseeability and remoteness type arguments, that I don't think there'd be too much harm in many cases if you actually do have a follow-on fixture lined up prior to chartering. And that's, that might be rare. Usually the follow-on fixture will arise during the charter. But it's not just in shipping context. It could be in a commodity contract or any kind of contract, frankly, commercial contract, where you actually want to put the other side on notice of some facts or some consequences that might happen if they breach certain aspects of the contract. So in negotiations, it's Hadley and Baxendale, right? If there's special knowledge, special facts that you're aware of and the other party is aware of at the time of fixing, you can actually say, well, you had knowledge, you had special knowledge that in this case that we had this follow-on fixture. And if you didn't meet it, that's a problem. And you went ahead and fixed on that basis anyway. And that's really the critical part of it, isn't it? You need to be able to show that the other side knew if they breached this provision, and this would be the consequence for you, and they took on that risk at the outset. They knew about it. They knew about that potential outcome and contracted on that basis. Then you might kind of navigate around this. So, you can almost say at times it helps to share information about what's going to happen if they breach, right?
Yeah, share your commercial information. The difficulty is I don't think you'd persuade anyone in the chartering team to say what they fixed their next fixture at. But you're right. This would basically, in I suppose in legal speak, you've got your two limbs of Hadley and Baxendale. Limb 1, the type of losses which are reasonably foreseeable at the date of entering into the contract. And you have the Achilles, you have the Great Creation, you have a number of other cases that say a follow-on fixture does not count for a Limb 1 Hadley and Baxendale. And what you're talking about is Limb 2 Hadley and Baxendale, where you're looking at losses which were not reasonably foreseeable at the date of the at the date of entering into the contract in the objective sense, but subjectively the parties knew about them. So if you can pull your losses into that second bucket, then you could feasibly recover them. But
it's interesting. Like I agree with you that the commercial team wouldn't want to divulge exactly what they fix at. Would they need to though? Well, would it not be enough to say we've lined up a follow-on fixture? It starts at this time. The vessel needs to be here. If you can't meet that, we're not going to fix with you. It was fixed at roughly market rates without giving a figure. I think probably what happens is the other party doesn't go ahead with the charter, right? And they say, well, we're not going to be bound to having no flexibility at the end of the charter. We're not going to fix with you. Maybe that's what the reality.
Yeah, we need to exclude those losses then. That's what I suppose that's what a smart charter would say. We'll have a consequential loss exclusion that will do the trick.
I didn't have much more to say on this. Did you?
No, I think in this case, just to round it off, here the failure was they redelivered in the wrong place. There was no date for redelivery. So the argument from the owner was effectively the argument for the charter from the owner was we should recover our loss of profits. If you had redelivered in the right place, we would get all of these profits on this other fixture. It would have been a 40-day fixture with a market differential of $4,000 a day. That's an extra $160,000 across the period. That's what we get. That's what we're entitled to. And the charterer said, no, the measure of loss for redelivery in the wrong place should be your net profit, which you would have earned on a hypothetical voyage from the actual place of redelivery to the intended place of redelivery. And that would be a substantially lower sum, or in the region of 20,000. And yeah, the tribunal agreed with the charterers, and they made an award in that amount. You'd imagine there was probably a settlement offer sat somewhere in that amount or close to it that charterers then could rely on in costs. But a short one, but an interesting one, and we see this issue a lot. Can you claim those not consequential losses for a loss on follow-on fixture? Well, it depends what you said at the time of chartering, I suppose.
Yeah, I don't think it would look very pretty for owners on costs on this one, even though they recovered 21 odd thousand. I think that's pretty much what charterers are offering to pay. So, okay, good. Well, I think we did do pretty quick. Did do that pretty quickly. 20 minutes still.
We've not hit the 10, but we're getting closer.
We're getting closer. All right, Calum. Always a pleasure. Look, thanks everyone for listening in. We hope you've enjoyed this one. As ever, if you want to follow us, you can find us in the usual places: Spotify, YouTube, Apple, Google. Thanks for listening in. Until next week, take care.
Cheers, everybody. Bye.